Larry Anderson and Johnathan McDonald to present the Appellate Award. You know, for those of us who sit there every Tuesday afternoon and hit refresh and wait for those Supreme Court opinions to come out, and you see how much work goes into it in the amicus committee and all of these cases, you really get a flavor of how hard these lawyers work. And this year's recipient is truly deserving, but I'll let Larry and Johnathan do the honors.
In our line of work, there's two kinds of lawyers. There's transactional lawyers and there's transformational lawyers. A transactional lawyer will take a set of facts and he or she will accept the state of facts. And he or she will take the law and accept the law as he or she finds it. And then they will settle the case for whatever they can get. A transformational lawyer, which is what all of us are in this room, will take the facts, and even the most mundane facts, the facts that we've seen many, many times, will transform those facts by digging deep into those facts and figuring out what are the fundamental values at stake with respect to those facts. And they'll make those facts into a much bigger case than the facts on first impression would appear. A transformational lawyer will not simply take the law as it is, but will recognize that the fundamental purpose of the law is that it ought to be just. And in order for it to be just, it ought to be right. And in order for it to be right, it ought to serve the interests of all of the members of society. This year's Appellate Advocacy Award winner is John Morrison. John Morrison, we all know about. He's had an extraordinary career, and frankly, it's hard for me to understand why he hasn't stood up here and received this award long before now. This year, he was involved in 4 cases in the Montana Supreme Court, and all of those cases were successful. And what's amazing, that in itself ought to be subject of recognition up here. But each of these cases in and of themselves are meritorious of receiving this award. We've heard today about 2 of those cases, the Gleason Estate case and the Graytack case. In both of those cases, they are insurance claims practices cases in which John recognized that the notice prejudice rule in both first-party cases and third-party cases needs to be very specifically defined. And John, in the Gleason case, he was counsel in the Gleason case. In the Graytack case, he wrote the amicus brief in that case. In both those cases, he established a fundamental principle that will be used in Montana, and we will always focus the notice prejudice rule in both first and third party cases. But as important in the Gleason case, he also focused a fundamental problem that plagues us all in insurance claims practices cases involving first-party insureds. And we are always sitting there with a conflict in our mind whether we proceed with the contract case and what we have to do to thereafter, if we're successful on the contract case, to also secure a bad faith verdict. Well, in Gleason, as you well know, we now can establish the damages in the tort case simply by establishing the damages in the contract case. Now, The case that I am excited about, and I think that exemplifies the concept of a transformational lawyer more than any that I've seen this year, is the Jessica Gazelka case versus St. Peter's Hospital. Jessica Gazelka was injured in a car crash in 2010. She was injured so badly that, and it was a clear liability case, that John secured the policy limits in that case of $100,000. And before that case could get completed, she was also hospitalized for a significant illness at St. Peter's Hospital. Well, the problem was she didn't have any health insurance, and so probably in that situation she ended up having a judgment taken against her for the illness, and probably in that situation a transactional lawyer would have said to Jessica, he would have said, "Jessica, I'm sorry, I can't help you with that. That's not my circus and that's not my monkeys. So you'll be on your own on that." That's not what John did. John focused this whole fundamental issue in the context of the delivery of medical services, in the context of the relationship between the health insurance industry and healthcare providers. And they were successful in getting a special piece of legislation passed that basically gives health insurers a deduction on the health insurance bills they pay because they are a, quote, preferred provider. And in this case, the deduction that they take is in the neighborhood of about 26% off of a patient's bill. So if you're uninsured, you will pay a higher bill than if you're insured by Blue Cross or some other health insurer in Montana. So what John decided to do is challenge that statute on two grounds: A, an equal protection ground, and B, he challenged it on the grounds that it violates antitrust law. Now, we ended up in Judge Reynolds' court, and Judge Reynolds had a very hard time with the equal protection issue, and he decided pretty quickly in the case that, as you well know, in Montana's equal protection clause, it's a much broader clause than the federal equal protection clause. It prescribes that, among other things, the state, no person, corporation, or any other entity can discriminate on the basis of a number of things that you all know about, including social condition or status. So John's position was that this uninsured status in the context of the delivery of health care is a status that violates the social condition provisions of the equal protection clause. And John went out and pulled experts from across the country to establish that point in a summary judgment motion. The problem was Judge Reynolds couldn't figure that out, and he decided that uninsured status is not a social condition. And without doing any other equal protection analysis in the context of the basic equal protection paradigm that we all operate on, he bounced the case on summary judgment. John took that up on appeal. Beth Baker, of all people, wrote a nice opinion, that actually expanded the concepts of standing in Montana, and she basically sent the case back to the district court to reevaluate the entire equal protection analysis, including the analysis of whether or not a social condition, or whether or not uninsured status is a social condition under the Equal Protection Clause. The thing that intrigues me about this case, and what really gets my blood going, is Justice Lori McKinnon's dissenting opinion in that case. Justice McKinnon says that this whole inquiry about the delivery of health care services and how it's done is not a matter for the judiciary to be worried about. And that reminds me and John of the basic concept that there's some members of the judiciary who really don't understand what their role is. And John, more than most, has a unique ability to help them understand what their role is. Since man frequented this earth, we've been operating on the law of nature. And we've been plagued by the law of nature, and that's why we developed communities. And we developed communities to protect us from the law of nature. Of course, the problem with communities is we ended up with majoritarian oppression. And so the majorities in the communities oppress the minorities in the communities. And so we then ended up with representative democracies, in which we thought representative democracies would protect the people through representation. And of course, that's why we have legislatures. And the problem, of course, is today legislatures don't protect the minorities. They protect and oppress the minorities. But that's why we have constitutions. And some judges don't seem to understand that the fundamental purpose of Constitution is to protect the minorities, the weakest among us, from the tyranny of the majority. And John Morrison understands that, and he's done a great job in developing this case, and he's going to see it through. The other case that is interesting to me, and I think John probably did this on his own time, is the MEA MFT's challenge to the legislative initiative 127 that was passed in 2013. That initiative basically would have eliminated party primaries. And so what would have happened then, we'd have one primary, and the two top vote getters in the primary would run in the general election. Well, you can imagine what that would have done. The problem for the legislature was that in order to accomplish that, they had to put in the title of the bill the fact that they were amending 111 statutes. So there's a provision in the Montana Code that basically says that the title of a legislative initiative can't have over 100 words. So when you count the 111 citations, the question is, are those words? And John spent the time and energy and went through the lexicon and the whole history of the concept of word to determine that statutory citations are indeed words, and therefore successfully defeated that legislative initiative. John, thank you very much for this, and we look forward to your presentation.
Well, first of all, this award and the ones that come after this are not nearly as important as the awards, the 3 awards that just came before. And I hope I get the names of everybody right, but could you please all give another round of applause to the Freelands and the Schrecken Gus and the Woods for their courage and what it means and how it motivates and inspires everybody in this room. Richard, I'm not entirely sure what the construction method is, but if it involves a well-placed 2x4, I can tell you that everybody in this room has had that temptation from time to time. After my freshman year of law school, my first law job was clerking for a lawyer in Southern California named John McCarthy, who was an insurance bad faith pioneer. And my first assignment was writing a Ninth Circuit brief. And I worked very hard, night and day, that first week to get a product that I thought John would be happy with. And then I presented it to him, and he went back and he read it for about 15 minutes. And he came back into my office, or the cubicle I was working in, and dropped it on my desk. And he said, "Don't just tell the court what the law is. Tell the court what the law ought to be." And I think of John saying that to me on a regular basis when bringing these issues to the courts, and I know that that's what really motivates all of us here. And it's an exciting thing and a privilege and an honor to have an opportunity to work with the talented, hardworking members of our judiciary to try to move the law forward so that it evolves in positive ways as our society evolves as well. Just a few thank yous. I want to thank my family. My wife Kathy and daughter Amanda are with us tonight. My daughter Allison's back working in Washington, D.C. right now, but I want to thank them very much for their support and encouragement over the years. I want to thank the members of our judiciary, without whom we would not be able to accomplish anything in terms of helping the law to evolve through these cases. I want to also thank the MTLA amicus committee and the many people who do volunteer work on so many of these cases to help flesh out the presentations that the litigants make to particularly the Montana Supreme Court, and the important role that plays in achieving some of these good results. And the last thing I want to do is thank you, MTLA. In 2006, I had a bad 6 months. My dog died, my dad died, I got some bad press, and I lost an election. And that summer, Al Smith called me up and asked me if I'd come talk at the MTLA convention in Polson. And I assumed it was because I was such a brilliant speaker. But I found out when I arrived and stood up to the podium that I was invited for another reason. And everybody in the room, most of whom, if not all of whom, had written generous checks to me in the previous 6 months and a couple of times before that, stood on their feet and gave me a standing ovation. And at the time, I was still pretty wounded, and I don't think I fully expressed my appreciation for that. And I just want to let you know that I do appreciate that moment in my life at a tough time, and that I continue to get solace from it from time to time, and I want to thank you for that. In 2008, at the convention in that summer, you presented me with a Public Service Award, and I was over being wounded, but I was probably on the healing end of that and a little cynical. And I think I also didn't fully express the gratitude that I have for that. But I have that plaque on my office wall, and I look at it from time to time from my desk, practically every day, in fact, and it makes me feel like the 8 years that I spent making $68,000 a year to do some public work was worth it. And if I didn't fully express my appreciation then, I want to take the opportunity now to tell you that when the people of this organization, my brothers and sisters, recognize me and express that support for me and validate what I do, it means a great deal to me. Thank you very much.